Again, my name is Martin. I'm from ITM Münster, and I want to talk to you about legal aspects of digital preservation. So let's take a look at the Computer Program Directive. We have three relevant limitations in the Computer Program Directive. First of all, the lawful acquirer limitation, the backup copy limitation, and the decompiling limitation. So the lawful acquirer limitation says that if there is no other contractual agreement that the acts referred to in point A and B of Article 5, for the if you forgot what I was talking about the reproduction right, shall not require authorization by the right holder when it is necessary to use the computer program. So this is something like the mirror of the temporary reproduction right from the Information Society Directive. Of course, when you have a computer program, you bought, let's say, Microsoft Office, and you installed that on your computer. And you bought that and you want to install it on your computer. Of course, you're allowed to do that because it's necessary to run the program. Or when you double-click on your Microsoft Word icon, you have a reproduction of a part of the program in the RAM. Of course, you're allowed to do that because it's necessary for the usage of your computer. But the problem is, I can think about any action of a DP system that could rely on this limitation, because the digital preservation process of a computer program is not necessary for the use of a computer program, so this won't work. We have skip that. One limitation everybody hops on in the second when they read that is the backup limitation. So making a backup copy of a person having a right to use the computer program may not be prevented by contract insofar as it is necessary for the use. That's what the directive says. Of course, the directive means not necessary for the use of the program, but necessary for the continued use of the program. So a backup copy is, of course, not necessary to use the program in the first place. The problem, the thing is, of course, we're not talking about backups when we preserve stuff, but many people think this may work somehow because it's a limitation that already talks about storing something and making a copy of something, a backup of something. So. But the problem is, first of all, you see there no alteration. So you are only allowed to copy something. Identical copies, making backups, no alteration. So migration, for example, wouldn't work. Can't do that. But let's say you really want to copy something. Well, the problem is the directive doesn't say anything about the number of allowed copies. The directive or the national laws only say if it's necessary for the continued use of the program. So what is necessary? How many backup copies are necessary? I can say it for German legislation. The German legislator thought, okay, one. It's one. Done. So if say whatever the computer program creator, if he sends you 2 copies, you're not allowed to do a backup copy. So maybe some of you use Mac or use Time Machine or Norton Ghost who mirrors the hard drives. So you're not allowed to do a backup when you have 1 copy. That can't work. That's stupid. That's insane. So a lot of scholars, at least in Germany and I know in the UK too, they say, of course you're allowed to do more than 1 copy. But so okay, 2 copies are allowed. Maybe 3 copies are allowed. I won't tell you any number of copies that are allowed because for your national laws, I don't know it. For Germany, it's a matter of discussion. But preserving processes means to capture processes again and again and again and put it in a DP system so that you are able to execute and exhume in 80 years the process back at any time. So it won't work to do that with maybe 1 or 2 or 3 or 4 or 10 copies. We need more. We need something like a freedom of copy. So this backup won't work. Really last limitation I will talk about is the decompiling limitation. I think everybody of you knows what decompiling is, and I bet you all know much better than me. So decompiling is something like a retranslation. So I told you the translation of something of a computer program is an alteration, and the alteration is copyright protected. So you are not allowed to decompile a program object code to the source code because it's in copyright infringement. If we did not have a limitation for that, in this case, it would be very, very easy for big companies like SAP, was if it's gone, and or Microsoft or whatever, to be able to control the whole market because they have the control of the interfaces. And if you want to create your own program and you need the information of their interfaces and you don't have a clue how to get them, they won't give them to you, you can do nothing about it. So the European legislator saw that problem and says, therefore, that the reproduction of the translation, if this is indispensable to obtain information that are necessary to achieve interoperability between two programs, then you are allowed to decompile. But again, this is very, very restrictive because many people in this second, when I read that, think, okay, perfect, I have to migrate something to my DP system, so I can decompile what I want to migrate, check that, alter it somehow, and then make it work in my DP system. But you're not allowed to do that. You are allowed to decompile a computer program, check what interfaces this program uses, and then change your system. Change the independently created computer program to make it run with the decompiled system. You are not allowed to change anything within the decompiled system. So, and of course, you're not allowed. You're only allowed to do that if you are a licensee or if someone does it on your behalf. And so this is a very restrictive limitation, which in many ways won't work for digital preservation. The only scenario I can think of where this decompiling limitation works for digital preservation would be something because of the time we didn't talk about, is emulation of something. If I want to create an emulated sphere to make a program run in my emulated sphere, I think I can decompile the program, check where the interfaces are, create my emulation, and then make it run. So this would be covered, this may be covered by this limitation. So,
how is that with the open source?
Excuse me?
With the open source.
Open source?
Yeah.
Well, open source is nothing else but a license. I mean, if there is no license, you have to comply with what I just told you. If you have open source, you have to check the open source license, and there are a lot of open source, different open source licenses, and most of them say you're allowed to do everything, a lot, reproduce it, translate it, whatever, as long as you keep the open source. So as long as you keep what you newly created open source. But it always depends on the concrete license, and if the license doesn't say anything about it, it's all about the legal, the national law you're in. So that's open source. So check. We talked about something is covered by copyrights, exploitation rights, and the exceptions and limitations. In the end, I told you a lot about problems, and now, in the end, I have to say that copyright issues are a very, very high risk regarding digital preservation. Exceptions and limitations don't work for many digital preservation issues, and we have two consequences. The first consequence is, of course, if you want to run or install a digital preservation system, it's good to know about copyrights. You have to be aware of who's the copyright holder. You have to be aware of what do you want to preserve, how do you want to preserve, which kind of action is that. I mean, of course, in Timbus we talk about process preserving, but as a lawyer, I always have to break this process down to what's somehow in the law. There's no law that says something about process preservation, only about preservation of computer programs and some other data. So you always have to think about that. What do I preserve? Do I preserve some other data, or do I preserve computer programs in any way within my process? That's the first consequence. Be aware of these issues while you plan a DP system. And for all the others, like the DPC, who are convinced that DP is necessary, we have to keep raising these problems, because there are limitations. For example, the backup limitation. There is a limitation that says, hey, you're allowed to do the backup. So why shouldn't there be something like a limitation that allows you to DP in any way? It wouldn't hurt anybody. Or let's say if it hurts anybody, we can fix that by, by payments or whatever. So we have to think about a way out of this problem, because, as I said, every digital action is an infringement of copyrights. So, yeah. Out, brand new. Don't want to miss that. There's a DPC Technology Watch report on IP rights by Andrew Charlesworth regarding UK law. I read that. I really like that. I couldn't use a lot of that because it's all about UK law, but it's very, very good if you're interested in this stuff, and just it gives a very good overview. And yeah, next year comes the ITM books.